All right, good afternoon, ladies and gentlemen. We are here for the sentencing portion regarding the State of Georgia versus Edrick Faust, SU 24 CR 0547. The jury having returned a verdict of guilty on all counts in the indictment. Ladies and gentlemen, in the audience, I want to take care of a few preliminary matters before we get started. The first is that no one in the audience, with the exception of media who have been granted a Rule 22 permission, can have their cell phones out and can have their cell phones out. So the first thing I want everybody to make sure is that if you have a cell phone and you are not the media who has been granted access, to put your cell phone away, please. And also, while you're doing that, to make sure that it is in the off position. I would appreciate everybody's cooperation on that. If there is anybody, of course, and I've mentioned this before during the course of all of our proceedings, if anyone does violate that portion of this court's order, having their cell phone out and certainly even using it, you will be escorted from the courtroom by the deputy and not allowed to return. The second thing I want to remind everyone, as I reminded everyone the other day who was here, is that this is a court of law. And certainly the court expects everyone to act accordingly. There will be no disruptions whatsoever, no outbursts of any kind, no yelling, no screaming, and no disruptions like that. If that does happen, I will stop the proceedings. The Sheriff's Department will escort that person or persons out of the courtroom. Everybody certainly was in full compliance the other day when the verdict was read, when I gave this same instruction. And I certainly appreciate everyone's abiding by that order very much, and I'd ask you certainly to do the same today. Is the state ready to proceed?
State's ready, Judge.
All right, Mr. Cruz, is the defense ready?
I have no other choice, Your Honor.
All right, thank you, sir. Mr. Faust, I'm going to address you now, sir. I want to tell you that, as you know, you have been convicted of all 12 charges as listed in the indictment by the jury, returning the verdict. I want to tell you that you have the right to pursue an appeal. If you cannot afford an attorney, the court will appoint an attorney to represent you for an appeal. I want to make sure you understand that filing an appeal has time limitations. You have 30 days from the date of sentencing, which will be today, to file a notice of appeal. Filing a motion for new trial also falls under that category of 30 days after the conviction sentence is entered. You also have 4 years if you choose to file a habeas corpus petition. If you cannot afford an attorney to represent you, the court will appoint an attorney for you. I certainly know that you will speak with Mr. Cruz today and other days about your rights of appeal, but I wanted to make sure you understood them. Do you have any questions for the court about those things? Thank you, sir. All right, if the state is ready to proceed, you may do so, sir.
Thank you, Your Honor. Judge, what the state would intend to do as it relates to our presentation of evidence concerned with sentencing is to begin by discussing the ranges and the counts on which Mr. Faust is to be sentenced from the state's understanding. At that point, Your Honor, I would tender in certain certified convictions in aggravation of punishment. Mr. Cruz has been provided copies of those. We would then offer 4 victim impact statements, Judge, from Miss Virginia Baker, Mr. Adam Baker, Miss Meredith Schroeder, and Mr. Kevin Baker. And after the victim impact statements, the state would make its recommendation to the court. As it relates to count 1, malice murder, the sentence is mandated by law as of January 19th of 2001 would be a sentence of life imprisonment. Counts 2 through 5, the felony murder counts, as a matter of law, since Mr. Faust was found guilty of malice murder, would be vacated. Mr. Faust is thereafter still eligible to be sentenced for each of the felonies that underlied those felony murder counts. That would be the burglary, aggravated sodomy, 2 counts, and then the rape. As it relates to the sentencing range for burglary being count 6, that would be up to 20 years. Count 7, the aggravated sodomy as it existed on January 19th of 2001, the state's understanding of that is that that would be a serious violent felony subject to the provisions of 1710 6.1 at the time, which indicates that when an individual is convicted of a serious violent felony, if they are sentenced to anything other than a life sentence, they are not parole eligible for whatever that sentence is that is imposed by the court. And the range on aggravated sodomy at the time was 10 to 30 or life. As it relates to, and that would be the same for count 10, Your Honor. As it relates to count 8, the rape count, that would be 10 to 20 or life. As it relates to count 9, the aggravated assault, that would merge with count 1 for purposes of sentencing. We've already covered the range on count 10. Count 11 would be up to 20 years, and count 12, possession of a knife, I'm sorry, count 11 was the arson in the first degree. Count 12, the possession of knife during commission of a felony would be 5 years, Your Honor. And Judge, would the court like us to continuing numbering exhibits from the exhibit number in the trial, or to start with 1 for purposes of sentencing?
That's a great question. I think we should continue with the numbers that we've been going on. Do you have the last number that was entered?
I do not.
Okay. Okay. We can do that. Sure. I think that sounds fine. Ms. Satterfield really is in charge of all of those numbers. That's important for her. So we'll start again with 1. She thinks that would be best. So go ahead and label whatever document you have as State's Exhibit 1, and then follow with any other exhibits you have in numerical order.
Thank you, Your Honor.
All right.
And Your Honor, I've labeled for purposes of sentencing State's Exhibits 1 through 6. Exhibit 1 is certified conviction from criminal action number 93 OR 36B, which was a sentence entered on an attempted robbery charge with a sentencing date, original sentencing date of June 7th of 1993. This document was for a first offender sentence. It was later adjudicated guilty. In State's Exhibit 2 is 96 OR 165J.
Yes.
I would object to the state attempting to use prior convictions in aggravation of sentencing. If my recollection doesn't fail me, we didn't receive notice that the state intended to use Mr. Faust's prior record for sentencing either the last day of trial or the day before the last day of trial. The state provided us with documentation stating that they intended to use Mr. Faust's record in aggravation of sentencing. As the Honorable Court is aware, under OCGA Section 17-16-4, Section A5, the law states that the prosecuting attorney shall no later than 10 days prior to trial or at such time as the court orders, but in no event later than the beginning of the trial, provide the defendant with notice of any evidence in aggravation of punishment that the state intends to introduce in sentencing. And that is a shall statute. The state failed, unless they could show something, because from what they gave me 2 days ago, 2 days before the end of trial or the last day of trial, that was my first time seeing those documents. But the state hasn't met the notice requirement to introduce evidence in aggravation of sentencing under that statute, Your Honor. So I would ask that if the state wants the Honorable Court to proceed with sentencing, that's fine, but I would ask the Honorable Court not to consider the state's evidence in aggravation because they failed to follow the proper procedure for admission of same. Thank you, Your Honor.
Thank you, sir. Any response, Mr. Yellenchilly?
Yes, Your Honor. I don't have both of the dates in front of me, but the state provided its first notice of intent to use any convictions contained in Mr. Faust's criminal record in aggravation of punishment as part of its discovery certificate that was filed on, I believe, April 2nd of 2025. Subsequent to that, we provided a more specific notice that listed 3 convictions coming out of Clark County, and then we amended that notice with the second notice of intent to use prior convictions in aggravation for recidivism, which doesn't necessarily apply here for purposes of impeachment as well. But the original notice is from April 2nd of 2025.
Thank you. Yes, sir.
I would ask the Honorable Court not to take Mr. Yalamachily's word for it. If the Honorable Court could review the record to make sure that it's accurate. I disagree with that position, but I may be mistaken. I would just ask the Honorable Court to confirm.
Okay, thank you, Mr. Cruz. I actually have reviewed the record, and Mr. Yalamachily is correct. So I'm going to overrule your objection. I'm also holding in my hand the state's second notice of intent to use prior convictions in aggravation of sentencing, and that was filed on October the 2nd. So I have one of them actually in my hand, but I have reviewed the record, and Mr. Yalamachily is correct, sir.
Yes, ma'am.
All right, thank you. You may proceed.
And Judge, so State's Exhibit 1 was a conviction for attempted robbery, Your Honor, with the date that I noted. State's Exhibit 2 is a certified conviction regarding possession of a firearm by a convicted felon and other offenses from 96 OR 165J, again, out of the Superior Court of Oglethorpe County. Then we come to the 4 Clark County convictions that the state intends to admit for aggravation. State's Exhibit 3 is SU 01CR0298. This was an aggravated assault committed on February 4th of 2001 involving cutting or another individual in the neck area, and the sentence date on that particular offense, I believe, was September 6th of 2001. Obviously, the offense date is within a couple of weeks of this murder. And then State's Exhibit 4 is SU 11CR0744. This is a certified conviction, again, for Mr. Faust for a felony. And it is a conviction for possession of cocaine as well as driving while license suspended and misdemeanor obstruction of a law enforcement officer. State's Exhibit 5 is another certified conviction. This is SU 13CR0203 out of the Superior Court of Clark County. And this is a conviction for possession of cocaine with intent to distribute, as well as misdemeanor obstruction of a law enforcement officer. And, Your Honor, the sentence date on this particular case is November 6th of 2013. And then State's Exhibit 6 is SU 14CR0774. And it's for a felony driving while license suspended, Your Honor. The conviction date of this case will be November 26th of 2014.
Yes, sir.
I just pulled up the notice that the Honorable Court mentioned from October. It only mentions 3 offenses. That's the aggravated assault. That's the VGCSA, 2 counts. I don't. Just wanted to let the Honorable Court know.
That was the only one I had in my hand, but I have reviewed the record.
I just want to make sure.
There's an amended notice as well, Mr. Cruz, but the one that I was referring to is the one I have in my hand.
Correct. The amended notice, I only received that 2 days before the end of trial, Your Honor. So we're asking that those convictions not be considered. The 3 that's in the notice filed in October, obviously that meets the statutory timelines. The ones that they gave me 2 days before the verdict came down, that does not meet the statutory timeline, Your Honor. So I'd ask the Honorable Court to reconsider its ruling.
Thank you, sir. Any response to the objection again, Mr. Yalamachily?
Well, again, Your Honor, if we go back to, and I believe it's April 2nd of 2025, but the court has the record in front of it, As part of the state's discovery certificate, we provided notice of both impeachment, aggravation, and I believe also recidivism for any convictions that were contained in Mr. Faust's criminal history. There's no, to my knowledge, no subsequent requirement of the state to make a more specific notice, but we chose to do so.
Yes, sir.
The law requires a specific notice, so there is a requirement for that, Your Honor.
I'm not sure that's correct, Mr. Cruz, and I'm going to overrule your objection and allow the state to continue.
All right, and so, Your Honor, if I could approach, I have states
You may.
1 through 6.
Thank you. You may proceed.
Thank you, Your Honor. At this time, we'd ask the court to hear victim impact statements, beginning first with Ms. Virginia Baker.
Good afternoon, Your Honor.
Good afternoon.
I am Tara's mother. I will always be Tara's mother. And I'm afraid my emotions are about worn out after these 25 years of pain. And so if it is okay, I have asked my son-in-law to read my statement for me, if that would be all right.
Yes, ma'am. That is certainly all right. Go ahead.
Thank you, Your Honor, members of the court. There are no words to fully express the horror of what this monster did to my daughter, Tara. For weeks, I have sat in this courtroom, forced to look at evil, to hear details I never wanted to know. I have endured it only for her sake. January 19, 2001 was the collision of pure good and incomprehensible evil. Over these 25 years, the truth has emerged slowly, each new piece more terrible than the last. The question that never leaves me is why? I have asked God this question thousands of times. I still have no complete answer, and the pain remains. As a mother, I cannot bear the image of Tara dying alone, frightened, calling for help that never came. Night after night, I dream of carrying her burned and broken body, walking endless roads trying desperately to find someone who could help, someone who could bring her back. I have begged God to trade my life for hers. She is gone. The emptiness she left is vast and unending. Tara was intelligent, kind, dutiful, and loving. She worked hard toward her dream of becoming a lawyer so she could help others. Yet she never lost her generosity or her caring nature. Her life was full of promise and light. The person who took her lived in complete opposition to everything she stood for. His actions were selfish, depraved, without compassion or regard for the lives he destroyed. He did not only end her life and her dreams, he tried to erase her completely by setting the fire. Our family had never known violent crime before that day. Her absence still wounds her siblings, her friends, and all who loved her. The pain is constant, even in moments that should be joyful. I will never forget sitting beside her closed casket, praying it was all a mistake, that we would open it and find it empty. Though I begged to open the casket to see my sweet girl one last time, my husband and the funeral director protected me from seeing the devastation that Edrick Faust had caused. The impossible hope that somehow she was not in that casket was the last thread I clung to before accepting she was truly gone. After 25 years of living in the shadow of this loss, praying, waiting, and enduring, the final chapter has been written today. As the district attorney reminded us, it was the jury's solemn duty to hold the pen and write the correct ending to this tragic story. They have done so, bringing accountability at last and allowing light to pierce the darkness that has shadowed our family for so long. Tara's beautiful soul is now safe with our Lord. Her short life was filled with love, and that love endures in every heart she touched. I thank God for the grace that has carried me this far. I thank him for my remaining children, Tara's siblings, and I thank him for my grandchildren. We all thank him for the legacy of light that Tara left behind. Tara was, and always will be, deeply loved. Such a beautiful life, so full of promise. Thank you for your time, Your Honor.
Thank you. Mr. Cruz, anything from the defense with regard to this victim witness?
No, ma'am.
All right. Mr. Yalamanchili, you may call your next witness.
Your Honor, the state would call Adam Baker.
On January 19th, 2001, my beloved sister, Tara Baker, was stabbed, beaten, strangled, raped, and finally set on fire. That horrific act was not where the tragedy ended. That is where it began. Tara was an extraordinary human being, beautiful, compassionate, driven, and hilariously funny. She was the best of us. I have never known anyone with a purer heart. Tara and I were more than siblings. We were best friends. From the day I was born until the day Edrick Faust ripped her from us, we were inseparable. She cheered me on at every step. My decision to join the Air Force, my dreams of flying, it was her dream for me to become a pilot. I remember how she beamed with pride after I joined the Air Force. I remember coming home on leave and her giving me the biggest hug. We talked so much about my training and what things were like. I also remember the moment she saw my dog tags and truly understood what they meant. She grew quiet. She cried. It was the first time she ever considered that my life could be cut short. Neither of us ever imagined it could have been the other way around. Being far from home meant I was alone when I learned of her death. My father was desperately trying to contact a military chaplain to sit with me when the news came, but I called him first. The cries of anguish I made during that call haunted him until the day he died. I still have nightmares in which our roles are reversed, and I am the one making that call, hearing the pain, unable to hug my son or comfort him. I remember the fog of arranging a flight back to Georgia, the long journey home, watching people board planes and go about their day oblivious. The flight attendants offered pretzels or cookies. All I could think was, I want my sister back. The entire flight, I dreaded one moment above all, seeing my mother. When I finally reached my parents' house and I saw her face, the anguish there was something no one should ever have to witness on their own mother. In hysterical grief, she held me for what felt like days, weeping and wailing. That evening, through her tears, she begged me to achieve my dreams because Tara could no longer achieve hers. Our focus is only Tara could have inspired me to do. I made every rank as early as military regulations allowed. Eventually, I was accepted to officer training school. My family attended my graduation. Tara was not there. I went on to flight school and earned my wings. At graduation, my family proudly pinned those wings on my chest, but Tara was not there. I met an amazing woman whom Tara would have adored. We married. At the wedding, we took family photos of the whole Baker family. Tara was not in them. Every Christmas, every family gathering, every milestone, Tara was absent. She never got to be a sister to my wife. She never held my infant daughter, beaming with pride as an aunt. She never cradled my twins when they were born. My oldest child has had to learn of her Aunt Tara through photographs and stories. She favors her. I mourn not only Tara, but everything that was stolen from us. Tara would have turned 49 last month. I have no doubt she would have pursued her dreams, achieved her goals. She would have married and had children. My beautiful nieces and nephews that I never got to meet. My mother's precious grandbabies, who now would be old enough to chase their own dreams and start their own families. An entire branch of our family tree was severed irreparably on that one day to satisfy one man's depravity. The last 25 years should have been full of life, laughter, and generations. But the pain doesn't end here today. Despite this verdict, the pain will continue. This summer, I will retire from the career that Tara inspired me to pursue. My family will fly out. We will celebrate. There will be pictures. Tara won't be in them. She won't be there. Tara's children won't be there. Tara's grandchildren won't be there. In fact, our dad, who died at the age of 59, due to the stress and grief of losing a child, will not be there. And he is but one of a list of family members who I am certain would still be alive today had it not been for the stress, grief, depression, and utter devastation caused 25 years ago. For many years, I wrestled with God over what happened. That struggle eventually and ultimately led me to a place of forgiveness. Long before I ever heard the name Edrick Faust, I chose to forgive him. Today, sitting in this courtroom face to face, I can honestly say, I have forgiven you. I harbor no hate in my heart. I've given that all to God. You will stand before him one day. I pray that before then, you will confess, you will repent, and you will seek for the forgiveness of Christ. He will grant it. Until then, I need nothing from you except this one thing, that you never hurt anyone else again. Your Honor, I leave that responsibility to the judicial system. Please ensure that Mr. Faust never has the opportunity to harm another person. Thank you, Your Honor.
Thank you. Mr. Cruz, anything from the defense?
In regards to this witness, no, ma'am.
All right. You may call your next witness, Mr. Yalamanchili.
Meredith Schroeder, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
During these last few weeks, we, Tara's family and friends, and all who loved her, were forced to relive this nightmare, to face the darkest time of our lives once more, to face things that we have avoided for 25 years. We sat and watched in horror the sight of her lifeless body, discarded like trash amongst the debris. We sat here in this courthouse and watched Tara be victimized once more, watched social media legal pundits co-opt our family photos as their own and opine on who they thought Tara was. I've watched as people came to spectate, like a morbid kid poking at her and us like dead animals on the side of the road. For all those interested parties, I will tell you who Tara was. She was our North Star, our champion. She was kind. She was determined. She wasn't perfect, but she was close to it. She spent her short life lifting people up and wanted to dedicate her life to making people happy. Happy Law was her dream, and she had carved out her path to achieve it, and no one hated her. On January 19th, 2001, Tara woke and began her day like any other. While that day will remain the darkest of our lives, it was nothing compared to what Tara endured. I cannot imagine the fear and anger she felt, how she fought, telling herself this was not happening. While Tara was our everything, it wasn't enough for Faust. For the last 25 years, he has wreaked havoc on this community. Just 2 weeks after he ended Tara's life, he put a knife into a man's neck. He shattered another man's jaw over a parking space outside the 40 Watt. He savagely beat his wife on a cruise and then later pistol whipped her with her own gun. While we have sat here trying to maintain our composure, I've watched the defendant sleep through proceedings. I'm terribly sorry to have inconvenienced him, but you see, while he got to walk free for the last 25 years, he dealt Tara and all of us a life sentence. He stole from her, he stole from me, he stole from my children, and he stole from all of us. None of us are the same people who woke up on January 19th, 2001. Every day for the last 25 years, I have literally thought about my sister. I've wondered if her wild and tacky sister would have made her proud. I've mourned the friendship that we were building outside of sister. I've mourned the tone-deaf car karaoke sessions and the Friday night rom-coms. I've mourned the life lessons that she tried to teach me, but my dumb teenage brain couldn't understand. The guilt that I feel that I've lived an entire life that was denied her cannot be measured. I have prayed that I've been strong enough for her, that I've fought enough for her. I've prayed these last few weeks that I've done right by her. Today I stand here, channeling her strength to face the man convicted by a jury of his peers to this nightmare, to let him know that after today, I will endeavor to forget his face and his name, to never allow him to cross my thoughts again. After today, I will live my life remembering how Tara lived. My final request is that this honorable court ensure that he is put somewhere where he finally ends his reign of mayhem. Thank you.
Thank you. Anything from the defense, Mr. Cruz?
Only to make 2 corrections, Your Honor. In regards to pistol whipping his wife, that is nothing that occurred or was evidence in this case.
I'll let you say that when it's your turn, but in terms of any questions you have for the
No,
witness.
absolutely
All right.
not.
Thank you, sir. You may call your next witness.
Kevin Baker.
Good afternoon, Your Honor.
Good afternoon.
Of course, indulgence as I get my paperwork here. It's maybe one of the most difficult things I've ever had to do. Your Honor, my name is Kevin Baker. I'm Tara's youngest brother, who she affectionately called her baby darling. There's a 12-year age gap between the two of us, so I wouldn't see her as much as a big sister as I would see her as a motherly figure. Over the past several days, I have sat in this room and listened to people argue over semantics while thinking that my Tara, beloved sister, cuddle buddy and protector, is gone. We're arguing over a Super Bowl and a World Series. Well, I can't tell you who won that game, but I can tell you every detail that happened that day. My earliest memories of Tara and I were singing Beatles songs and Elvis songs and having a dance party in the living room. We watched old movies like Wizard of Oz and the Braves game on TV as we would cheer on her boys to victory. I even told her as a young boy I was going to play baseball and I was going to be just like Chipper Jones, who she adored so much. She would sit there as I would tell her that, and she would smile and say, "You could do whatever you wanted to do as long as you put enough effort into it." To help me sleep, she would tell me Bible stories and hold me close when I was scared of the dark or when things would go bump in the night. Everywhere Tara lived, she invited me to stay at her house. From her dorm at Georgia College to the 80 Pie house, I was always welcome, where most college girls would think having a 9 or 10-year-old little brother following them around a college campus would be annoying and maybe even a bit embarrassing. But she saw it as an opportunity to connect and show me how doing well in school can benefit you. I remember the last time I saw her. It was towards the end of Christmas holiday. Adam was home, and she thought how great it would be to have a siblings' day out. She took us out, myself, Adam, and Meredith, to Chick-fil-A for lunch. We laughed, we carried on, and had a great time as a family. It was probably my last true happy memory as a child. She said goodbye to me in the driveway. She bent down on one knee and gave me the warmest hug and a white turtleneck sweater and a brown leather jacket and a kiss on the cheek. She told me to do my best in school as a new school year would be starting. In a few weeks, she would be back to visit with just me. She planned to come home and visit with me and go to my baseball game. I started that next school year with just the focus on school and sports. Then came Friday, January 19th, 2001. I was taken out of school, oblivious to what was happening at the time. My parents were in a panic and dropped me off at my grandparents', who would soon drive me up to Athens. But before we made our way to Athens, I asked my grandparents if it would be okay to get something to give to Tara as a gift. My grandparents, already knowing what was happening in the situation, couldn't bear to be the ones to give me the news. So they took me to a Hobby Lobby. I got a dolphin figurine and I made it for her, not knowing that she would never receive it. I arrived at the Holiday Inn right down the road from here. As a child of only 11, I was given the news by my late father that there was a fire at Tara's house. My immediate response was, "Is she in the hospital? Tell me she's okay." My dad stood there, choking back tears, saying, "No, buddy, she didn't make it. She's gone." At that moment, my childhood innocence was destroyed. It would be shadowed by grief and running around this college campus with flyers asking who killed my sister, asking questions, not knowing anything other than she was gone. Learning words that no elementary school kid should ever have to learn or know happened to his big sister. Words such as rape, stabbing, arson, and murder. Kids at school would say, "We're sorry for your loss." I was only thinking to myself, I didn't lose her. She was stolen from me. Where most kids would come home to a warm house full of happiness, I came home to a house, despite my parents' best efforts to create the best environment possible. It felt more like a mausoleum than a warm home. Unlike my siblings, I went through the majority of my life, from childhood, teenage, and adult phases, without Tara. Unable to ask her, "Am I doing okay? Is this what I should be doing in school or in life? Would you be proud of the man your baby brother has become?" I strived to be just like her throughout my childhood. When I received awards, graduated high school, and graduated college, Tara was not there. When my father died, which this murder took years off of his life due to stress, instead of Tara holding me while giving me the news of my father's passing, I fell to my knees in a hospital parking lot at midnight alone to collect myself and be strong for my mother, who was already in the ER room waiting for me to arrive. I found love and married, and instead of a family being in the front row, I had 2 empty chairs with 2 white roses for both my father and Tara, who would have been there if the situations had been different. As this trial goes on, I have read and seen the absolute best and the absolute worst of people in both this courtroom and outside who seek to turn a sensitive matter into a circus of calamity and pandemonium for their own entertainment, for likes on their social media pages, all the while seeing how this trial has opened up old wounds and exposed horrible memories. I have heard how this man is sitting here fighting for his life. Well, it makes me think about something about that morning. Did Tara have a chance to fight for her life? Who was there at the moment when she needed someone the most? No one, because she was scared and she died alone. Your Honor, I've listened to details for the first time that I've never been told about this case, not because the case was not thoroughly investigated, but because of the horrific and gruesome facts that my family tried to shield from me due to the age at the time. Your Honor, when that verdict was read, the person that's sitting here in that pew that day is not the 36-year-old man that stands before you right now. It was that 11-year-old boy who brought back all that pain and loneliness of being in that hotel room knowing that his sister had just been killed. As a father of a young girl, I dread for the day that I will have to give the tale to my daughter of her Aunt Tara, not for being the loving aunt who would have loved her so much or strived for greatness, but as a cautionary story of safety, because someone thought that they could play God and decide who should live and who doesn't. I've taken my grief and I've used it as a career to help others during their time of loss and guide them through their grieving process. It gives me peace to know that none of these families that I will undoubtedly have to help in the future will not be caused by this man's reign of terror in this community. I pray that there will not be another family in this community that will have to deal with the same pain and sorrow and cruelty that we have had to deal with over these past 25 years. This is not the final chapter of Tara's story, because once this case is concluded and her story will live on in everyone who ever knew her and everyone who ever loved her, despite this man's best efforts to destroy her legacy and destroy her body. She will endure in our hearts forever. For those who are in this courtroom or maybe watching at home, I ask you this. Will you remember her? Because she would remember you. Thank you, Your Honor, for your time.
Thank you. Anything from the defense, Mr. Cruz, of this witness?
No, ma'am.
All right, thank you. You may call your next witness.
Your Honor, we don't have any other witnesses. We're ready to make our recommendation at this time.
You may proceed.
Thank you, Your Honor. I cannot offer anything more important or more impactful than what Tara's family has already said, and I will not try. The court has heard the evidence in this case and all its brutality and depravity. It's horrific, even in the context of other murder cases. The state's recommendation in this case is as follows. On count 1, a sentence of life imprisonment. On counts 2 through 5, vacated. Count 7 would be 30 years confinement concurrent with count 1. Count 8 would be life consecutive to count 1. Count 9 would merge with count 1. Count 10 would be 30 years consecutive to counts 1 and 7 while being concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11. The total sentence would be 2 consecutive life sentences plus 45 years of confinement with 60 years of non-parolable concurrent confinement with those 2 life sentences. That's the state's recommendation, Your Honor.
All right, Mr. Yeoman-Shell, you went through that very quickly, so I'm actually going to ask you to go through it slowly so I take down what you say, and I will do the same, of course, for Mr. Cruz. If you'll do it a little bit slower for the court, I want to make sure I know what you are asking for, and then I'll do the same for Mr. Cruz.
Yes, Judge.
Start with count 1.
I will, and just for an overall, again, in total, we're getting to 2 consecutive life sentences plus 45 years of confinement with 60 years of non-parolable confinement concurrent with those 2 life sentences. And the way that we structured that was in count 1, life. Counts 2 through 5, vacated. Count 7, 30 years concurrent with count 1. Count 8 is life consecutive to count 1. Count 9, the aggravated assault, merges with count 1. Count 10 would be 30 years consecutive to counts 1 and 7 and concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11.
Thank you.
Thank you.
Anything else from the state?
No, Your Honor.
All right, thank you. Mr. Cruz.
Would you like us to start with mitigation before we get into sentencing?
Yes, certainly you can. If you are presenting witnesses, this would be the time to do so.
All right, thank you.
Thank you.
I had a lot of inquiries, if I may. If you're here to testify on Mr. Faust's behalf, can you raise your hand for me? 1, 2. All right, you all come up to the front row.
Mr. Terrell, can you help with the podium here? And then maybe we'll put a microphone, put it in between the tables. That would be very helpful. Thank you.
Your Honor, the first witness that we have is Miss Kinsey Faust.
Good afternoon. How you doing?
Good afternoon.
My name is Edrick Faust, and I'm speaking on behalf of my cousin, brother, Edrick Faust. And the picture that being painted as a monster, he's no monster. He's a human being. He has family that loves him and care for him. With all this, I want justice to be served, and justice to be served the correct and right way. And all has been said and presented throughout the court system. I've been here day one, ever since Mr. Faust got arrested back in 2023, whenever it was. Like I say to this day, I want the Baker family to get justice. And I feel that justice was not served. And I feel that they're painting a picture of Mr. Faust like he's a monster. He's no monster. He has family, grandkids, kids, and all. And he has lost people also. My father, which is his uncle, which helped raise him. And I know my father raised me, and my father did not raise no animal, nor monster. And I ask you, Lisa, today, as you get ready to sentence Mr. Faust, to really look at the justice and the way things should be laid out. Because Mr. Faust, my cousin, I love him. My brother, we raised in the same house, like I keep saying. He's no monster. He's a human being. And things that happen to Tara, I am a female too. And I hate all of that. But I would like for justice to be served, and to be served the correct and right way.
Thank you. Ms. Giallo-Chile, anything from the state?
I don't have any questions, Your Honor.
You may call your next witness.
Your Honor, next we have Mr. Bryson Shields.
How you doing, Miss Lisa Lott?
Good afternoon.
I know E. I used to walk car with him.
You'll pull that microphone out.
I'm sorry. I used to walk cars with E. And like last witness, he's not no monster, man. And I'm sorry for what happened. But justice wasn't served here. So that's all.
Thank you. Ms. Giallo-Chile, anything from the state?
No, Your Honor.
You may call your next witness, Mr. Cruz.
And I'd like to make a statement for on behalf of Mr. Faust. And I know it's unique for the attorney to do so.
Go ahead, sir.
But, Your Honor, you're aware that obviously our system is a system of laws. And once the jury renders a verdict, regardless if we agree with it or disagree with it, that's the law we follow. That's the procedure we follow. I would ask the Honorable Court to consider in its sentencing, and we know what the mandatory sentencing is in this case, but we would ask the Honorable Court to consider things that took place in this case. As the Honorable Court is aware, and obviously we don't relitigate issues, Mr. Faust didn't have opportunity to explain his DNA. Mr. Faust didn't have opportunity to argue consent. There were things, and throughout this trial, I spoke the truth this entire trial. Not one time did a dishonest statement come out of my mouth. But as I advised the Honorable Court, I've reviewed every piece of discovery in this case. And this case is a true tragedy. The very first time I stepped in this courtroom, Your Honor, I said in order to get justice for my client, I would have to get it for the Baker family. And obviously I failed at that. The jury decided otherwise. But, Your Honor, I presented the evidence that I could present to the Honorable Court, to the jury as well. I am aware of the mandatory sentencing schemes, but I do know the Honorable Court at the end of this and upon sentencing typically gives its own proffer or statement to the defendant in regards to the Honorable Court's thoughts and the reason it's given the sentence that it is giving. I would ask the Honorable Court if it would consider this is a case of very unique circumstances. And obviously, the evidence that we presented, again, the jury, as the finder of fact, found that our theory was not the truth. But I would just ask the Honorable Court, when it renders its sentence, to give the lesser on the lesser end, even though it's mandatory, but also in regards to the Honorable Court's statements to the defendant, or Mr. Faust, which will come. I just ask the Honorable Court to keep everything in mind, because Your Honor is aware of a lot more than I was able to present to the jury. And that's all I'd like to say to the Honorable Court. To the Baker family, this is a heartbreaking case. And as an advocate in this case, no one, the state and I would disagree completely, but no one would ever say that this wasn't a tragedy. And I give my heartfelt, and I mean my heartfelt from the bottom of my heart, my heart goes out to you all and what you've been through. But, Your Honor, I just ask you to consider that when it comes to your statement to Mr. Faust at the time of sentencing. Thank you.
Thank you, Mr. Cruz. Do you have any specifics with regard to counts 1 through 12 you'd like for the court to consider?
I do. My other two witnesses just arrived, Your Honor.
All right. You may present your witnesses, sir.
Hey, my name is Katrina Faust.
Good afternoon.
Edrick Faust isn't a monster. He is a very lovely, funny, and hard-working person. Edrick will always be my cousin, my brother, and I ask God to protect him. I pray to God to give him strength every day and to keep his mind together. And his family will keep fighting for justice for him. Edrick Faust isn't the killer. He was accused as the killer, but he isn't the killer. And he also have a family that love him. And we're going to keep fighting for justice for him as long as it takes. And I'm sorry for the Baker family. And I'm sorry for my family had to keep grieving over this. Because it's been very hard for the Faust family too.
Thank you. Anything from the state, Mr. Yelmichilli?
No, Your Honor.
You may call your next witness.
My name is Shonda Smith, and I would like to speak in reference to my cousin. I'm his first cousin, Edrick Faust, and I would like to say, Your Honor, my name is Shonda Smith. I stand before you today on behalf of my cousin, Edrick Faust. This is an incredible, difficult moment for our family. We are watching someone we love face sentences while firmly believing in our hearts that he is an innocent man and he has been wrongly convicted. Edrick is more than what has been presented in this courtroom. He is a son, a father, a cousin, a brother, a man of faith who has always been a source of support in our family. This man, he knows he's kind, he's compassionate, and he's deeply valued by those who truly know him. As a family-rooted as our family rooted in faith, we believe in justice, but we also believe in mercy, grace, compassion, and the truth. God sees what we cannot see. God knows what we do not know. We humbly ask, as you determine the sentence, we consider his character, his strong support system that stands behind him. And I hope that this still remains in his future, if you could see his future as a loving, bright, intelligent man. Thank you for allowing me to speak. As I do love my cousin, I hope the Baker family finds justice, because this is not it. Thank you.
Thank you. Anything from the state, Mr. Yelmichilli?
No, Your Honor.
Mr. Cruz, any other witnesses?
No, ma'am. Just discussion regarding
All right.
One more, Your Honor.
Go ahead, sir.
Good afternoon. My name is Tijuana DuBose.
Good afternoon.
I stand here today heartbroken, not just for Edrick, but for the Baker family. I have witnessed this for the last couple of years, and is very heartbreaking. I'm sorry what has happened, but I just ask that you guys just look at my cousin as not being a murderer, because he's not. I understand that something did happen, but he wasn't the one that did it. I understand the Baker family would like to have peace and justice for what has happened to their daughter, but at the same time, you have the wrong guy. If I wasn't here myself, if someone told me what happened, I would say, this is not true. But I witnessed everything, and the things that I witnessed, I can say everything was wrong. Everything was done wrong here. I understand people had a job to do, and they want to protect themselves and their job and their family. But at the same time, it's two families that did not get justice. Edrick Faust family did not get justice, and the Baker family still don't have justice. So I just ask that God continue to step in, to guide us and lead us and direct us to the right person that did do this. But as you guys do what you have to do, you have the wrong guy. And I stand here today and I firmly agree on what I say. I'm the first cousin of Edrick Faust. We grew up together. I knew him. I'm 48 years old. We're just a couple of years of difference. But I've been here and I know the things that Edrick done. Our grandmother has been in our lives, and Edrick is a good person, but I'm not going to say everything he has done in his life has been good, because everything I've done has not been good. But at the same time, I don't feel like you should get punished for something that you didn't do. So I just ask you guys to just do what you have to do, but at the same time, know that God has the last word. I love you.
Thank you. Anything, Mr. Yelmichilli from the state?
No, Your Honor.
Anything else, Mr. Cruz, in terms of witnesses?
No, ma'am.
All right. And anything else you'd like to tell the court with regard to counts 1 through 12, just
Yes,
as the
ma'am.
state did? Go ahead.
Yes, ma'am. Your Honor, I ask the Honorable Court to exercise its discretion. I understand in count 1, malice murder, the jury found Mr. Faust guilty of malice murder, and the Honorable Court, the only option the Honorable Court has is life with or life without parole. We would ask the Honorable Court to, in regards to count 1, for the lesser sentence, which is life, the lesser sentence, which is life with parole, in regards to count 1. Counts 2 through 5, those vacate as a matter of law. Count 6, our request is a 1-year sentence on the burglary, Your Honor, and as the Honorable Court is aware, and I stated before, our system is a system of laws, and we have to respect the jury's verdict. The reason I'm asking for 1 year on the burglary count, Your Honor, is based on evidence that the Honorable Court heard, which is the state providing to the jury that they couldn't show that Mr. Faust or how Mr. Faust got into the home. The Honorable Court could weigh the evidence in regards to the burglary charge. The Honorable Court is aware, and the Honorable Court can make a decision as to whether or not the evidence was overwhelming that Mr. Faust broke into Ms. Baker's home. So that's why we're asking for 1 year on the burglary count to be served concurrent. And that's count 6. Count 7, in regards to aggravated sodomy, and that was the oral sodomy, the Honorable Court's discretion is only from 25 years to life. If the Honorable Court issues a sentence of 25 years, I believe the statute requires that the remaining portion, if I'm not mistaken, is remainder of probation for life, if I'm not mistaken. So I'm asking the Honorable Court in regards to the aggravated sodomy oral for the lesser sentence in regards to the court's discretion, which is 25 years. I would ask that that sentence is concurrent to count 1. And if I didn't state it with count 6, I'm also asking the 1 year is concurrent to count 1. In regards to count 8, Your Honor, I believe count 8 and count 10 merge based on the language of the indictment. The language of the indictment provides that the basis for the rape in court's indulgence the indictment specifically alleges that Mr. Faust had carnal knowledge of Ms. Baker. However, when it comes to aggravated sodomy, which is count 10, which is the anal charge of aggravated sodomy, carnal knowledge includes anal sex. His sexual organ entering Ms. Baker's sexual organ. So we would say that count 8 and count 10 merges. In regards to count 10 merging into count 8, Your Honor, the Honorable Court's discretion is only 25 years to life, similar to Count 7. We would ask the Honorable Court to exercise its discretion and sentence on the lower end, the 25 years with probation for life. We would ask that that is concurrent to Count 1. In regards to Count 9, aggravated assault, the Honorable Court is aware that the sentencing range is 1 year to 20 years. We would again ask for the lower end of that range, which is the no, please forgive me. Aggravated assault merges into Count 1 by law. So please forgive me. Count 9 merges into Count 1 by law. As I mentioned in Count 10 merges into Count 8. Count 11, arson, 1 through 20 years. We're asking that the Honorable Court exercise its discretion and sentence Mr. Faust to 1 year, concurrent with Count 1. And in regards to Count 12, I believe the statute does not give the Honorable Court discretion in regards to the sentence being consecutive. And I believe it's a 5-year consecutive sentence to Count 1. So the total sentence that we're asking for is life with parole plus 5 years, which is the mandatory minimum that the Honorable Court could sentence Mr. Faust to. As a significant piece of the mitigation, as I mentioned, Your Honor, is that I hope the Honorable Court takes into account the evidence that came out in this case. I do believe when Mr. Faust was initially arrested, it caused an uproar in Athens because a lot of people assumed that, hey, we've got the right person. It's just based on this new technology that the GBI had. But once we came into the courtroom, Your Honor, the jury, the Honorable Court, and we respect the jury's verdict, I'm not relitigating that, but the Honorable Court, in regards to mitigation, heard significant evidence that was never stated before in regards to Mr. Melton's involvement in this case, in this crime, which was rejected by the jury, which I acknowledge. But the Honorable Court is also aware of the rulings that were adverse to the defense, and I'm sure the Honorable Court says, hey, it was 412, it was 412, it was 412. I respect the court's ruling. I disagreed on the record. But, Your Honor, you could take everything that came into this case, all the information that came out in this courtroom, and you can make two choices. You can either say, hey, there were some questions in this case. By law, I'm required to sentence this way. I am going to use my discretion and sentence him to the lower end. It's still a life sentence, Your Honor. Or the Honorable Court could say, hey, I heard the information that came out in this case. I reject all of it, and I'm going to sentence him to what the state requested, which is the maximum sentence on everything. I am not from Athens. However, this case has caused a divide in Athens. Just like I witnessed, the Honorable Court had the opportunity to witness, this courtroom was split down, and I hate to even discuss it because it's a difficult topic to discuss, but the courtroom was split pretty much down racial lines. The Honorable Court made concerns and, had concerns and discussed social media with both counsel. I didn't look at social media until after a verdict was rendered in Mr. Faust's case. And the damage that this case has caused in the Athens community is mind-blowing. There's some people extremely upset. There's also some citizens that are extremely relieved. But, Your Honor, in your position, you have the power to send a message, whether that's I'm going to give Mr. Faust the absolute worst sentence he could get, or I'm going to take into account everything that came out in this trial, and I'm going to sentence him within the guidelines as required by law, but I am going to sentence him to the minimums, and that's what we would ask, Your Honor, and I thank you so much for your patience.
Thank you. Mr. Lamichilli, do you care to respond to the argument by counsel about merger of Count 8 and Count 10?
Yes, Your Honor. I mean, Count 8 and Count 10 do not merge. The carnal knowledge is defined in the rape statute as penetration of the vagina by the penis, and it doesn't merge with aggravated sodomy. I know I don't think any of the ranges that Mr. Cruz gave were based on statutes as they existed in 2001. I think he's going off the statutes as they exist currently. I think it's incumbent upon the state in our role in the process to point out that given that it's a murder from 2001 and no notice of intent to seek death was filed, it's not a death penalty case, Mr. Faust can't be sentenced to life without parole. I believe the maximum is life because the statute was changed subsequent to when the crime was committed in 2001. So I do want to point that out. Also, as far as the 25 to life range, again, by our review of the statutes, that's not correct. On the rape, I believe it's 10 to 20 or life. And on the sodomy, I believe it is 10 to 30 or life. So I do just want to clear up those factors. I think that's a misstatement of the law. And I'm not going to respond to some of the other things that Mr. Cruz said. Obviously, the court knows what it ruled and didn't rule, but I don't think those are accurate statements of the way the proceedings were conducted.
Thank you. Anything further, Mr. Cruz, about the issue of merger?
Sure. If I could have a second to look at the statement, the law, and it should take maybe a minute, 2 minutes at most, to look at the law in regards to what statute applies at the time of sentencing or at the time of.
Go ahead.
Thank you. The state is correct. The statute at the time of sentencing. If I could have a second, Your Honor, to look at the statutes. I looked at the current law and applying the sentencing ranges. The Honorable Court would allow me to look at the statutes at the time of in 2001, if that's okay.
Okay. Thank you, Mr. Cruz. So, ladies and gentlemen, I'm going to adjourn. I'm going to consider both parties' arguments to the court. That'll give you time, Mr. Cruz, to look at the statutes. I'll be back on the bench shortly. I do want everyone in the courtroom to know that the Sheriff's Department is in charge of the courtroom. And if they ask you to remain seated while they allow other persons to enter or exit, they are allowed to do that. I'd certainly ask for your cooperation. They are in charge, again, of the courtroom. I'm going to be adjourned for just a little while. I'll be back on the bench. And Mr. Cruz, if you have anything else you'd like to add with regard to looking at the statutes at that time, you may do so.
Yes, ma'am. Thank you.
All right. Thank you. All right. Counsel. Yes, sir. Did you want to say something?
Yes, ma'am. I had an opportunity to look at the law. We withdraw the merger. I did look at the law from 2001 in regards to aggravated sodomy and rape. We withdraw the merger from that count. Count 1 was correct. You have the option of life or life without parole. Count 6 is correct. It's still 1 through 20 years. But we would change our request to count 7. The minimum is 10 years, so we would ask for 10 years. And that's in regards to the aggravated sodomy. Count 8, rape, is 10 to 20 or life. We would ask that the Honorable Court exercise its discretion and sentence Mr. Faust to the 10 years, and count 10 as well as the 10 through 30. We would ask the Honorable Court to exercise its discretion and sentence Mr. Faust to the 10 years. Thank you, Your Honor.
Thank you. All right, counsel. I'm actually going to give you both, all three of you, 15 minutes to do some homework, and here's why. The state has asked the court to sentence this defendant to the maximums, and the defense has asked the court not to do that. And of course, the 2001 law is not something that is readily accessible and readily available, and it is a little bit different than the law now. The question I have for both counsel is, pursuant to the rape statute and also to 1710 6.1, what your position is on whether the rape charge carries the possibility of life without the possibility of parole. I'm doing some research based on the state's request and the defense's request as to whether in 2001 that was a possibility. 1710 6.1 is the violent felony, the statute that applies to violent felonies, and I think there is an understanding among cases that happened back then that the count of rape could carry with it the possibility of life without the possibility of parole. I'm going to ask the three of you to look at that. I'll give you 15 minutes. I'm going to go finish my research. I'm asking you to do that because both parties have asked for opposite ends of the sentencing structure. State has asked for the maximum, which they are contending is life on that charge, on the rape charge. The defense is asking, of course, for that not to be considered. And so because of that, I'm going to ask you all to look at that. Yes, sir. Anything before I leave the bench? All right, I'll be back in 15 minutes. Thank you. Thank you. Please be seated. That's what I was looking up. Exactly. Yeah. All right, we're going to go back on the record. I'll speak to the state first. Anything else the state would like to add with regard to my comments about what is now the statute 1710 6.1?
Yes, Your Honor. And I looked at two cases during the time period the court gave us. The first is Velasquez v. State. It is a 2007 Court of Appeals case out of Georgia. The citation is 283, Georgia Appeals 863. There's no negative treatment for that case noted on Westlaw. And also Henry v. State, which is a Court of Appeals case from October 13th of 2017. And the citation on that is 343 Georgia Appeals 157. In Velasquez, the court states that, let's see, our Supreme Court held in State v. Ingram 266, Georgia 324, that a life sentence without parole was authorized only in cases in which the state first sought the death penalty, and we are bound to follow that precedent. And then in Henry, which is a case in which a life without parole sentence was imposed, but due to a 1710-7C recidivist situation, the court, again discussing Velasquez, states that Henry is correct that under normal sentencing, a trial court may not impose a sentence of life imprisonment without the possibility of parole unless the state sought the death penalty in the case. I did see some of the cases which I think the court is making reference to. In the way that they read in the time period that we had, it seemed to be a situation in which the jury had found or not found, or the court had found or not found, aggravating sentencing circumstances that refer back to the death penalty statute's definition of aggravating circumstances. So, there's always the possibility that I'm wrong, but it is my belief, although if the court were authorized to impose a life without parole sentence, I wholly think it would be appropriate under the circumstances of this case. However, I do believe that I have a responsibility to represent to the court what I believe the law to be, which is that we are limited to a sentence of life on both the murder but also the rape. Thank you, Judge.
Thank you. All right, Mr. Cruz, anything else that you would like to say? This is a legal issue, but we need to make sure we are certainly following all the requirements of the law, particularly as it relates to what the legislature intended in 2001. Go ahead, sir.
Thank you, Your Honor. I don't think I have a position here because we're not asking for a life sentence when it comes to the rape charge, Your Honor.
Okay. All right. Thank you, sir. The reason that the court wanted to ask counsel to look at the law on that is because both sides are, of course, diametrically opposed, really with regard to count 8, which is the rape count. And the court had a memory of some of the law from 2001 as it related to sentencing. 1710 6.1 was a different statute in 2001, but the idea of 1710 6.1 was the same back then in 2001, and that particular charge, rape, falls under that statute as a serious violent felony. There are orders, particularly one out of the Superior Court of Clark County, that which was not overturned, supports the notion that under the recidivism notice and statute, that a maximum sentence for a rape charge back in 2001 supports the possibility of life without the possibility of parole. The question then becomes, if that is correct, is whether the recidivism relates back to anything prior to 2001, or does it relate to something after 2001? And so that certainly can be up for debate, and we're not going to debate that now based on the state's not seeking that maximum sentence. The maximum that they are seeking in count 8 is life, and so we will leave it at that. But that is the reason I wanted to ask both of you to look at the law and see really what was applicable in 2001, because both parties, of course, are diametrically opposed in terms of the maximum and minimum amount the court can allow. All right. With that being said, Mr. Yelman-Chile, anything else from you?
Nothing further from the state, Your Honor.
Thank you. Mr. Cruz, anything else, sir?
No, ma'am. We'll just note for our record the recidivist notice objection that we made prior.
I understand, Mr. Cruz, and I want to respond to that very quickly. Looking online to make sure that my notes comport with what I saw online, the notice that the state referred to in their discovery, which was filed with the court, was from April the 2nd of 2025. It was entitled the State's Notice and Recidivism Notice in Discovery. That was from April 2nd of 2025. The notice that the state is relying on now, that the defense has responded to, of course, the 3 felonies that they have enumerated in their notice, is from October 2nd of 2025. And so anything further, Mr. Cruz, you'd like to say about that? All right.
No, ma'am.
All right. Thank you. All right, very good. All right.
Well, make the record clear. So from October 2nd, 2025, it's aggravated assault, VGCSA, 2 counts of violation of Georgia Controlled Substance Act offenses. Looking at the recidivism statute, I'm just saying these are the offenses that we have notice of. The state has asked the court to take to consider other offenses that there was no notice given. The state's argument when we brought this up initially was that, hey, in discovery we just filed a general notice and whatever could be used as for purposes of recidivism. Our argument, it does not. It has to be specific. So we are on notice of these 3 specifics.
Thank you. All right, so I just want to respond to that very briefly. The law allows the state to provide notice in the manner in which it did. From April the 2nd of 2025, their general notice in their discovery that they filed with the court, and of course the actual notice that they provided the defense on October the 2nd. I will say, however, that the court is going to take into account in sentencing Mr. Faust the notice that was filed October 2nd that the defense has no objection to, and that is the one that I will certainly take into account in sentencing. With regard to this case and sentencing and taking into account the notice that was filed on October 2nd of 2025, the state's argument about sentencing and the defense's argument about sentencing, the court finds as follows. Mr. Faust, please stand. This court finds, based upon the evidence presented at trial and the jury's verdict, that a sentence involving rehabilitation is not appropriate in this case. And I'm going to sentence you, Mr. Faust, as follows. With regard to count 1, life. Counts 2 through 5 are what we call in the legal world vacated. That means no sentence, and that is imposed as a matter of law. Those are the felony murder counts. With regard to count 6, which is the burglary charge, 20 years consecutive to counts 8 and 10, which I will get to in a moment. With regard to count 7, which is the first aggravated sodomy charge, 30 years, and 20 years is 20 years confinement. Count 7 is 30 years in confinement. That is concurrent with count 1. Count 8, the rape charge, is life. That is consecutive to count 1, which is the other life sentence. With regard to count 9, the court agrees that count 9 does merge with count 1 as a matter of law, and that's the aggravated assault charge. With regard to count 10, which is the other aggravated sodomy charge, the court imposes 30 years in confinement. That is consecutive to count 1 and 7. That is also concurrent with count 8. Count 11, which is the arson and the first-degree charge, the court imposes 20 years of confinement consecutive to count 6. And count 12, which is possession of a knife during the commission of a felony, the court imposes 5 years in confinement. That is consecutive to count 11. The order of the court are 2 consecutive life sentences to be imposed, plus an additional 45 years to be served in confinement. That'll be the order of the court. You are in custody. Thank you. Court is adjourned. And everyone, please remain seated until the Sheriff's Department determines who can leave and when they can leave. Thank you very much for your cooperation.